I would like to introduce our next two speakers, Eric Ruben and Kevin Bleyer, whose dad you met earlier. Eric Ruben received his JD from NYU School of Law, where he was an articles editor for the NYU Law Review, and his BA from Dartmouth College, where he graduated magna cum laude. Ruben's scholarly interests span criminal law, constitutional law, legal ethics, legal empiric, and legal history. His current scholarship explores the regulation of violence and weapons and how that regulation intersects with self-defense and Second Amendment rights. Ruben teaches criminal law, professional responsibility, and a seminar on the Second Amendment. Ruben has had several publications and has been cited by the Supreme Court of the United States, the United States Courts of Appeals, and in legal briefs. He has testified before the U.S. Senate Judiciary Committee and frequently provides legal commentary for popular news outlets. Kevin Bleyer is a multiple Emmy and Peabody Award-winning writer for late-night and episodic television, an occasional speechwriter for presidents and astronauts, and the author of, among other books you most likely haven't read, the #1 Amazon bestseller. I did not write that, by the way.
You have not read it, right?
And the book in his hands is Me the People, One Man's Selfless Quest to Rewrite the Constitution of the United States of America. And with that, Kevin and Eric.
Thank you, Linda. Yeah, sure. Why not? Oh no, sit down. You're embarrassing yourselves. I feel like we've already met briefly, so forgive me for that rude interruption, but it kind of felt like it had to happen earlier. My name is Kevin Bleyer, and first off, thanks, of course, to Texas Doctors for Social Responsibility for inviting Eric and me to be a part of this. It is an honor to be here, but if you had told me I'd have to follow my father and that I wouldn't get to speak until he commanded the room for an hour, I'd say, sounds like a typical Friday morning, including the PowerPoint presentation. I'm not kidding. Yes, as a bit of a professional smart aleck, I was tempted to open with a bit of a joke and say something like, it's a very good thing that doctors are on the case working hard on this issue, because if there's one thing the founding fathers back in Philadelphia did when wrestling with those vital issues of governance, civics, and law, they said, quick, let's ask the physicians. But I can't do that. I can't do that because I looked it up, and they did ask the physicians. This is a bit of history, but I promise it'll be of some interest to both the legislators and the high school students in the room. Of the 55 delegates, I have it here, of the 55 delegates who attended the Constitutional Convention in 1787, 3 of them were doctors. Not sure that they wore white coats, but I think the powder wigs might count. 35 of them were, of course, lawyers, so Eric, you were well represented. And of the 55 signers of the Declaration of Independence in 1776, 5 of them were doctors. And you could tell they were doctors because no one could read their handwriting. That's a very easy physician joke. What does that say, John Hancock or 5 milligrams of tetracycline? We don't know. Thank you. Well, we got a big laugh for the woman in white, the white coat. Perfect. And I will even tell you the names of those 5. Those 5, Matthew Thornton, the delegate from New Hampshire, Lyman Hall, the delegate from Georgia, Oliver Walcott, the delegate from Connecticut, who studied medicine but never practiced, Benjamin Rush, the delegate from Pennsylvania, who was a high-ranking surgeon in George Washington's Continental Army, and for you West Wing fans, the delegate from New Hampshire, Josiah Bartlett, who was the namesake of Jed Bartlett in that show. There were no Texans. Why? Because there was no Texas at the time. The doctors in the room might have heard of Benjamin Rush. He was not only the most well-known physician in 18th century America, he also considered himself, and I quote, a patriot, philosopher, author, lecturer, fervent evangelist, politician, and dedicated social reformer, as do many doctors here. He was also, it was said, quote, stubborn, self-righteous, caustic, humorless, and polemical, as are many doctors. I'm allowed to say that as the son of a doctor. And so that's, and actually I would say it makes sense that they were in the room in 1787, because we should remember that at the time the country already had a first constitution, if a weak one, in the Articles of Confederation. Eric knows all about that. So the doctors in that room, to the doctors in that room, the Constitutional Convention was essentially one big second opinion. And that's what we're doing here. Oh, that was I got a groan from this side of the room for that one. But that is what we're doing here, wondering if the Second Amendment should get a second opinion. Well, I wrote a second opinion on the entire Constitution. That's one of the books you haven't read, including a chapter on the Second Amendment. And Eric and I thought that perhaps as a way to set the table historically, I might speak first so that Eric, who actually knows what he's talking about, can bring us into the present. Eric's a real expert. In my book, I only pretend to be one. So here's the part of the first chapter on the Second Amendment. The Second Amendment, starring Charlton Heston's Cold Dead Hands. The Second Amendment is serious business. So let's start with the joke. Panda walks into a cafe. He sits down, orders a sandwich, devours it. When he's finished eating, he pulls out a pistol, shoots the waiter, and starts to walk out. "Hey," shouts the manager. "Where do you think you're going? You just shot my waiter." Panda yells back at the manager, "Look, man, I'm a panda." Panda tosses the manager a badly punctuated wildlife dictionary, and on his way out the door mutters, "Look it up." Panda leaves, and the manager quickly thumbs on his way into the correct entry. Panda, a bear, native of China, eats, shoots, and leaves. Okay, not much of a joke. It's not my joke, and I'll admit it's a terrible joke. But in the content of the Second Amendment, which does have a constitutional right to bear arms, but not a constitutional right to arm bears, it's a vital one. Don't worry, I will explain. But first, America is gun country. Our nation was founded by gun owners. George Washington owned 50 guns. John Adams wrote that arms in the hands of citizens were a great method of private self-defense. Thomas Jefferson received his first firearm at age 10. Years later, Jefferson advised his 15-year-old nephew, quote, "A strong body makes the mind strong. As to the species of exercise, I advise the gun." Full disclosure, I too have enjoyed shooting guns the few times I've done so, although I admit I don't quite see, as Thomas Jefferson does, their inherent exercise value. My mom warned me about running just with scissors. I understand the visceral appeal of firearms. They go boom. They feel American. They are American. America was born with the shot heard around the world, and we made a name for ourselves, for better or worse, by fighting wars all over the earth. The Chinese may have invented gunpowder, but Americans invented reasons to use it. Guns in America aren't merely protected. At times, they've been mandatory. The Second Amendment to the Constitution protected the right to bear arms, but only 3 years later, President Washington signed the Militia Act of 1792, a bill requiring, quote, "every able-bodied white male citizen between the ages of 18 and 45 to provide himself with a good musket or firelock, a sufficient bayonet and belt, two spare flints." The list went on. More than 2 centuries later, there are over 280 million guns in civilian hands in America. Nearly enough for every able-bodied man, woman, and child to point, if they chose to do so, at every man, woman, and child. During her failed vice presidential campaign of 2008, Sarah Palin had a handy way of summarizing the American devotion to guns, at least among her supporters. Quote, "We'll keep clinging to our Constitution, our guns, and our religion, and you can keep the change," unquote. It wasn't as catchy as it was, you might say, redundant. To many Americans, our guns are our religion because it is mentioned in the Second Commandment of our Constitution. Did I say commandment? I meant to say amendment. Second Amendment. You see my point? The one that states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." We cling so dearly to our guns because we've seen what happens when we don't. We vaguely recall our 17th century British ancestors who enjoyed the right to bear arms until King James II, fearing that Protestants might bear arms against him, authorized his Catholic deputies to seize the weapons of all subjects deemed to be, quote, "dangerous to the peace of the kingdom." In other words, Protestants. That's right, thank you. Only after a full-scale revolution, the Glorious Revolution, was the right of individuals to own guns re-established. Well, we weren't going to fall for that. No one was going to take our guns away. When the British Crown again tried to disarm its foreign enemy, this time the American colonists, we would have none of it. And today we feel the same. 3 out of 4 Americans believe that the Second Amendment protects their right as individuals to bear arms. Outside the United Nations headquarters in New York City, there stands an iconic sculpture. I'm sure you've seen it. A giant .45 caliber revolver whose barrel has been tied into a knot, rendering it useless. It is meant to represent nonviolence and pacifism for nations around the world. For many Americans, it merely represents a waste of a perfectly good giant gun, one that could have been used to shoot a giant moose. Nonviolence might be swell for the UN, but that's not how we do it in the US of A. As a country, we're locked and loaded. We pledge allegiance to the flag, but we're a gun nation under Glock with licenses and ammo for all. Well, not all. We may be locked and loaded, but we've also taken care to keep the safety on. Guns have been a part of America from the beginning, but so has our understanding that they should be regulated. Even the founders supported shockingly severe gun control laws. They denied gun ownership outright to anyone who declined to swear loyalty to the revolution. All white men, since they were considered to be part of a militia, were required to bring their guns to mandatory inspection or musters, where the government would catalog their weapons on public rolls, essentially required registration. And in a move that would have made King James II proud, and let's be honest, would likely never fly today, gun owners had to submit to impressment. If the government decided it needed the gun for its own use, it could confiscate them. It wasn't an idle threat. 10 of the 13 colonies impressed private citizens' firearms during the war against England. As America expanded, so did the struggle to hold our fire. Lawless frontier towns, where, Hollywood tells us, countless scores were settled by shootouts at high noon, had at least one sensible gun control measure. Strangers had to hand over their pistols to the sheriff or leave them with horses on the outskirts of town. Leaving guns with horses is not quite arming bears, but we're getting closer. So it's inevitable that we're a country divided between what are called sometimes gun nuts and gun grabbers, between those who read the Second Amendment as guaranteeing individuals the right to guns and those who see a guarantee only for militias, by those who believe the people have an unlimited right to keep and bear arms, and those that believe gun owners can be well regulated, which is precisely the problem with the Second Amendment. It is, in the words of one constitutional historian, maddeningly ambiguous. That alone is reason enough for me to rewrite the amendment. As written, it's ambiguous, maddeningly so. And it seems to me that the last thing we should do to someone wielding a gun is make them mad. That's been the core of the question put to, I skipped a page. Okay. Now, if there's one thing that I'm going to speak for you, Eric and I agree on regarding the original Second Amendment, it is, in fact, ambiguous to some degree. It is terribly written. It makes no sense. I defy you to follow its obvious logic. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. Excuse me, did I miss something? I think I missed something. Oh, it starts clearly enough. A well-regulated militia, I might not have capitalized militia, but that's just me. Then a comma, then being necessary to the security of a free state, fine, there are no hiccups yet. The sentiment so far is clear. Some kind of local army, comma, would be nice. But did you notice what happens next? It seems to start over with a new thought, a new sentence. The right of the people to keep and bear arms, comma, shall not be infringed. What happened to the first part? Did the writer just lose his train of thought? Did someone else then take over without bothering to see where his stricken predecessor had left off? In the end, what exactly does the first half have to do with the second? Hard to say, easy to argue. I admit I'm a stickler for good grammar. Bad grammar, as Churchill might have said, is the sort of English up with which I shall not put. So I'm tempted to fix the sentence regardless of the consequences. What's certain is that if either Eric or I had composed such a sentence in elementary school, it would have been returned to us crossed out in red. It is exactly the kind of clumsily crafted, poorly punctuated, grammatical word soup that would make any fans of the English language go off half-cocked. But it raises a more urgent warning. Thanks to its maddeningly ambiguous grammar, comma, when it comes to opportunities to draw contrary opinions on what this amendment actually means, comma, this thing is loaded. As written, the Second Amendment could mean two things. One, A, we all get to have a gun. Two, B, we only get to have a gun if we're part of a well-regulated militia. And that's been at the core of the question put to the Supreme Court, whether, as was true for most of American history, the Second Amendment was accurately understood as promoting merely the right of citizens to form militias, or whether, as the National Rifle Association began arguing in the 1970s and throughout the Heston administration, the amendment, in fact, protects the right of ordinary individuals to bear arms willy-nilly. Interestingly, even the NRA has rewritten the Second Amendment. Outside their former offices on Rhode Island Avenue, they chose to display only the part they liked. The right of the people to keep and bear arms shall not be infringed, no comma. Perhaps there wasn't enough room to mention the part about the well-regulated militia. Just think of it. With a clearer constitution, every time an individual claimed his right to pack heat, we wouldn't have to make such a federal case out of it. And yet we do, and in 2008, the Supreme Court did. 4 years before I rewrote the Constitution, so did a man who I got to know a bit in researching this book. He became a bit of a lunchtime companion, and that is, of course, Supreme Court Justice Antonin Scalia. In deciding District of Columbia v. Heller, Scalia, who was on his shooting team in high school and often rode the Manhattan subways toting his 22 caliber rifle, true story, or so he told me, he wrote an opinion that relied as much on Strunk and White as it did on Blackstone's commentaries. The Second Amendment, he wrote, is naturally divided into two parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, but rather announces a purpose. Of course, Scalia had a purpose of his own. His lesson in grammar was just a preamble to his very own rewrite. Quote, the amendment could be rephrased. Because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For a man who complained that the Supreme Court too often rewrites the Constitution, it's hard not to notice that he just rewrote the Constitution. He couldn't resist the temptation to join James Madison and me in the small fraternity of presumptuous men who have claimed to know just what the founders intended, who have parsed a sentence that utterly defies parsing, who have tried their hand at rewriting the Second Amendment to the Constitution. Which brings me back to that joke, the one about a panda who shoots the waiter and splits. As I said, it's not a good joke, but it makes a good point about the dangers of bad grammar. If a panda, quote, eats, shoots, and leaves, it's just a harmless panda that eats, shoots, and also eats leaves. If a panda eats, comma, shoots, and leaves, it's a panda that commits cold-blooded murder. And if there's one thing both armed pandas and the Second Amendment have taught us, is that bad grammar can kill. Punctuation poorly placed in the wrong constitutional sentence can result in guns poorly placed in the hands of irresponsible individuals. Rightly or wrongly, when the bad grammar is left uncorrected, it's chaos. Supreme Courts decide our fates, individuals get their paws on pistols, pandas go on shooting rampages, it's chaos. So where would I put my red pen? What would my amendment say? This one isn't easy for me to answer, for one reason only. In July of 2011, my friend Gabby Giffords, the Democratic congresswoman from Arizona, was shot. My God. I didn't expect to get emotional. Now you see why I began with the joke. I knew where this was heading. On that day, my thoughts on guns evolved in an instant, inevitably so. I can't simply reaffirm the right to bear arms, as Scalia has done, and as I previously was inclined to do. One of those arms forever changed the life of someone I care about. And yet, I take my cue from Gabby. Before the shooting, she didn't mince words. I am a strong supporter of the Second Amendment, she said. Gabby owns the same type of gun that was used in her attempted assassination, a Glock semi-automatic pistol. And by her own account, she's, quote, a pretty good shot. She was among the more than 300 members of Congress who signed an amicus brief urging the Supreme Court to strike down the ban on handguns in D.C. And when it passed, she celebrated. As a longtime gun owner, she said, I believe the right to keep and bear arms should not be dependent on the city in which you live. She happens to live in a particularly gun-loving part of America. Gabby's district is home to the OK Corral and Tombstone. The previous year, someone had shot a pellet through the window of her campaign headquarters. Yet, just a few days before the shooting, when Congress read the entire Constitution on the floor of the Capitol, Gabby didn't read the Second Amendment. She read the first. She was honored to do so. She would support anyone's right to speak freely, but she had also begun to feel that it had gotten out of hand. She would often email me when things were getting truly crazy, as when her window was shattered, or when a former militia leader encouraged people to throw bricks into local government offices to protest healthcare reform. The night before she was shot, she sent me an email that would take on new resonance only hours later. My poor state, she wrote. The nut jobs have taken it over from the good people of Arizona. I do think that gun ownership is an American right. It is the privilege of a free country. It is the cost of doing democracy. As Chief Justice Joseph Story proclaimed, the right to bear arms is, quote, the palladium of the liberties of a republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers and will generally enable the people to resist and triumph over them. It's the American way. Have gun, will triumph. Also, they go boom. But I do think gun control measures but do I think that gun control measures should be so toothless that an emotionally disturbed nut could have access to one? I do not. Nor do I think pandas should shoot waiters. So how do we stop that? I'm not sure. I can only use the powers that I have: sentences, prefatory clauses, operative clauses, commas, and hell, if punctuation can somehow confuse the issue enough, if more commas can make more courts consider new interpretations that might keep weapons out of the hands of wackos, then on behalf of James Madison and my friend Gabby, I'll do whatever it takes, period. So where are we now? As you all know, that within the span of 2 months, there have been 2 presidential assassination attempts, and we're in a position where a leading candidate for president just last week said, quote, if someone breaks into my house, they're getting shot. And the person who said that was not the Republican. It was the one talking to Oprah. That seems a pro-gun thing to say, and not at all ambiguous. With that, I've already gone over my time, like father, like son. And now we turn to Eric, who, in honor of that candidate, can talk about what can be unburdened by what has been. And since we're in the Capitol, I feel compelled to say I yield the balance of my time over to you, even though it's not my time in the first place. Eric.
I'm going to be a lot less funny. It's a tough act to follow. You could probably see it was, but you could see I would rather read a Constitution written by Kevin Bleyer than by the sharpest minds in the country. That was John Stewart. I hope everyone could see why. Go buy the book. I read it recently, and it's absolutely fantastic. I'm going to start where Kevin started and then jump forward to where he left off, because he mentioned that there were a bunch of founding fathers who were doctors, and we're a room full of doctors. And one of them who he mentioned was Benjamin Rush. Benjamin Rush also is known as the father of American psychiatry, because he wrote the first textbook in the United States on what we would now call mental illness, but he called diseases of the mind. And in it, he addressed depression, which he called melancholy or madness. And he talked about some of the experiments that he had done, his practice experience. And a lot of what he found, I think, would shock you. I had the pleasure, it was of reading his textbook about 6 months ago. And I finished yesterday. Yeah, exactly. So he thought that mental illness, what we now know as mental illness, was caused by blood disease in the brain, the capillaries of the brain in particular, and that in order to cure it, you had to bloodlet. So doctors, what you should do is you should apply horse leeches to your patients, or you should cut them until they faint. If that didn't work, they could consume mercury, which, as he described, would distract them from their problems and refocus it on pain in the mouth. He found that people with colored hair were more susceptible to melancholy and diseases of the mind than light-colored hair. You're lucky. I'm not, although I'm going gray. And other things that he talked about were drinking porter and specific types of alcohol. He designed a chair, which, as far as I can tell, did nothing other than just hold your head steady, which apparently would help cure melancholy. And at the same time, and that was the medical understanding at the time, but at the time, suicide itself was viewed as an immoral act and a crime. People thought that you were possessed by the devil. if you committed suicide. And there was something that us lawyers nowadays think would be completely odd, which is that after somebody died by suicide, there was a posthumous inquiry. A coroner with an inquest jury would investigate the death and decide whether or not it was a suicide. And if so, that person would be dishonorably buried on the side of a highway and could forfeit their goods. I'm going to loop back to all that in a little bit. It's relevant. I promise you, it's relevant to the Second Amendment, believe it or not. So to pick up where Kevin left off with Heller, in Heller, for the first time in this country's history, the Supreme Court struck down a gun law on the basis of the Second Amendment and said that the amendment is primarily not about the militia, but rather about private self-defense. And that move resulted in the hundreds or thousands of laws that we have in the United States being exposed to challenge on the basis of the Second Amendment, because everyone has a right to self-defense, but not everyone is actively involved in a well-regulated militia. The weapons that you could use in self-defense are not the same weapons that could be used in a militia. So it completely transformed the Second Amendment and made it a much more potent guarantor of gun rights. What I want to address primarily is what happened after Heller, which is that thousands of cases were brought. This was predictable. Thousands of cases were brought. In the 15 years after Heller, the Supreme Court largely stepped aside and the lower courts were resolving those disputes. I'm not going to dwell on this a lot, but suffice it to say that they applied the same doctrine that we use for First Amendment cases, which is a mix of history and a balancing of contemporary costs and benefits. And in doing so, they actually upheld over 90% of the laws that got challenged. Most challenges failed. But I'm not going to dwell on that because the Supreme Court, newly reconstituted during the Trump years, started taking more Second Amendment cases. They were out of the business of doing Second Amendment cases between Heller and then there was a case called McDonald in 2010, but then they really weren't getting involved until 2022 when a Bruin case came before the court. It was a challenge to a New York state permitting law. The court struck down that permitting law, but what's more important going forward is that it scrapped the way that the lower courts were deciding Second Amendment cases and set forth a new doctrine. The court didn't do this in Heller. The court in Heller didn't tell courts, and by doctrine, us lawyers mean the rules and standards that judges use to decide whether or not a given law is constitutional or unconstitutional. In 2022, the court did that. In an opinion by Justice Clarence Thomas, it was a 6-3 opinion along ideological lines, and he developed and set forth a novel way to decide Second Amendment cases. In order for a modern day law to be constitutional, if it implicates the Second Amendment, it has to be analogous in some ill-defined sense to regulatory tradition from the late 1700s or maybe into the 1800s. And I'm going to try to bring this around to the Benjamin Rush piece. I didn't, as Kevin was talking, I'm like, wow, this is a way to make this relevant to doctors. How do we nowadays, there's been talk about the risks of suicide. Nowadays, through statistical analysis, population level studies, we appreciate the presence of a gun in the home increases the risk of suicide in the home. There's lots of empirics that we're hearing today. The statistical know-how wasn't available to the founding generation, nor was the technology the same as it is now. This was an era of muzzle loading firearms that weren't kept loaded in the house because of risks of fire and for other reasons, and thus they couldn't be readily used in an impulsive manner. At the time, suicide was viewed as a crime and an immoral act. It was criminalized. We don't view it that way anymore. So what Bruin said was that for suicide prevention, in essence, for a suicide prevention law today to be constitutional, it has to be analogous to regulatory tradition back then, but we didn't view things the same back then. It invites anachronism. The test invites anachronism. And not only that, one of the things that happened after the 2022 decision in Bruin was that courts were deciding cases, and the Bruin test was supposed to make the Second Amendment more administrable. More laws were struck down after Bruin. A lot of laws were struck down, but for every law that got struck down, you could probably find another court somewhere else in the country that upheld a similar policy on the basis of the same historical record, because history doesn't speak with one voice. So it's been jurisprudentially, it's been a mess in the years after Bruin. That's the technical legal term. That brings us forward to this past June, and I'll talk about one more opinion that came down, and then I think I'll stop and open it for questions with remaining time. This past June, the Supreme Court decided the next Second Amendment case after Bruin, a case called Rahimi. Rahimi involved a domestic violence law. In particular, there's a federal law, it's 18 U.S.C. 922 G8, that says that if somebody is subject to a domestic violence restraining order, they cannot possess a firearm. And the facts of this case are telling. They actually arose here in Texas, in Arlington, Texas. There was a guy by the name of Zaki Rahimi who, in an incident, met the mother of his child and an ex-girlfriend for lunch, and got into a dispute with her, dragged her across a parking lot, shoved her into a car. When somebody saw them, he retrieved a gun and fired it. Unclear whether or not he fired it just into the air at anybody. Nobody got hurt. She was able to get away. And he called her up, said, if you say anything about what just happened, I'm going to kill you. She did, in fact, say something. She went to court. She took out a restraining order against him that barred him from possessing firearms. Despite that, he didn't give up his firearms, and he basically went on a shooting spree. 5 incidents or so over the course of several months. One of them, incidents like he went through a drive-through at Whataburger and credit card got declined, and he took out a gun and shot it. Like it was totally unhinged. Anyway, he gets caught, prosecuted under this law, and says this violated my Second Amendment rights to have a gun. And the Fifth Circuit agreed with him. Said that back at the founding, we did not disarm domestic abusers. Now, for what it's worth, women at the founding were not politically and legally equal to men. There was something called a right of chastisement, which allowed husbands to discipline their wives and children. It was a different world. But the court in the Fifth Circuit, in this Texas case, said we can't find any analogous tradition. The Supreme Court took that case and then reversed the Fifth Circuit. They said, no, in fact, even though we've announced this historical test, the law is not supposed to be trapped in amber. It can evolve, and what courts need to do is they basically need to move up a level of generality and look for principles behind our regulatory tradition. And the Supreme Court looked to non-domestic abuse laws and found analogous traditions. Is this going to make things better going forward? I'm not confident it will. In fact, the justices in that Rahimi case disagreed on how to do the Bruin test. There were 6 opinions. And they all disagreed with one another about how to do this historical analogical test. And since that case, I continue to see opinions coming out where some courts are basically looking for dead ringers in history and striking down modern laws. Others are doing it differently. And I guess I'll just conclude by saying, what does this mean for the research community? I think that in light of all this uncertainty, stay the course. Like a lot of times I'll get phone calls and say, okay, well, I'm a researcher. Should we stop researching? Is this just going to get struck down as unconstitutional? And there's so much uncertainty right now that outside the context of a few areas where it's settled, like you can't ban handguns. Heller told us that. We know that. You can't do a New York style permitting law. Bruin told us that. But outside the context of settled matters, there's so much uncertainty that my advice is just to stay the course, continue to try to find empirically sound ways to reduce gun violence in this country, which has reached epidemic proportions. And we're going to have decades of Second Amendment case law where we try to flesh out exactly what this right means. So I'm going to stop there, and I know that we're toward the end of the hour, but happy to take questions for whatever time is available.
All the hardball questions go to him. Yeah, thank you for providing that insight. I think that something that is super interesting to me is like the historical aspect that like both of you kind of talk about. I mean, like up until, I mean, you mentioned Tombstone, Arizona, where Gabby Giffords is from. Tombstone had laws where you had to like turn in your firearm, right? Like 1830s, Wild West. Wild West was not that wild. It's a fabrication. Yeah, exactly. And then like up through like the 70s, you have like local ordinances like Morton Grove getting lots of steam where they have like local firearm restrictions. But then that kind of energized the NRA to like make that statewide push that's really caused a lot of trouble for us. But like, I guess my question is like, in terms of like the jurisprudence aspects, like when we look at, yeah, sorry, feel free to weigh in. But like, and I know it's super unclear, but like, how would we push? Is it like more of an aspect of, hey, like if there's a local ordinance in like a blue state where we might have like more democratic justices that would like uphold things, like, if we wanted to be like, hey, because Tombstone had a law back, historically, we like like Tombstone passes like the same thing. They're like, all right, well, it's the same thing. Like, does it get brought up to the Supreme Court? Like, is it going to get appealed? Like, I don't even know what the process looks like. I think and maybe you don't either because it's just so novel, but.
Well, legally, it's a mess. Yeah, that's the legal, no, it's a mess, yes. No, so you raised a good point about the Tombstone era. Even here in Texas, and the representative mentioned this before, that the law changed in the 1990s. From 1871 until that law changed during the George W. Bush administration, Texas had very strong concealed carry policies, very strong public carry policy. You couldn't do it. And then if you did and you were caught, you could raise an affirmative defense and said, I was carrying because I had this particularized need to do so. But what the Bruin Court did was it took that Texas law, which supported the then existing New York state law, took examples like Tombstone, and in Clarence Thomas's opinion, he said, this was too old. Texas isn't representative of the population. This was too local. I have a friend who called it Goldilocks history. Like some was, it was too hot, it was too cold, it was like what, and it just created a problem where how many laws make a regulatory tradition that we can use to justify today's laws? What percentage of the population had to have been governed by these laws in order for it to be a valid tradition for the purpose of today's Second Amendment? The Supreme Court hasn't answered those questions. Any answers to them will be arbitrary. It's going to be arbitrary line drawing. And so this is one of the reasons why there's been so much confusion in the courts, that in ideology. There's an article that came out that said that outcomes in Second Amendment cases have become incredibly ideological because of how easy it is to parse the historical record to reach your desired outcome. So going forward, I'm not sure. I think it's going to take. Either the Supreme Court's going to have to decide on the constitutionality of every single issue, because it can't actually provide enough guidance on how to do this historical analogical test. We scrap the test or something else. I'm not sure, but it's a mess.
Just a quick follow-up, and maybe we can talk about this afterwards. But I don't know because I know like if we were talking about like you kind of mentioned there's so many different laws historically. I feel like there's a similar doctrine with like the patchwork argument for like preemption laws at the state level, where local governments aren't allowed to pass like ordinances about firearms, which has been a big barrier to state action. Do you think that there's any like legal argument that's been invoked, or there's like potential that maybe they could be like, hey, we didn't even have like a bunch of preemption laws or like a statewide or national-wide standard for firearms until like the 70s onward, and then they make the 70s that basis? Or I don't know if that's like anything that's come up at all.
It's really interesting, and I agree. I think preemption is probably a bigger hindrance to gun policy than the Second Amendment, to be sure. And I'd have to. I'll talk to you more about how that might be relevant. I haven't done a lot of thinking about it, but I would say that anything that happened in the 1900s is going to be most likely to be construed by the current Supreme Court as too recent to actually inform what the Second Amendment, which was enacted in 1791, means.
Yeah, so on the topic of, I know you guys have been mentioning ambiguity a lot. How do you think that Chevron being overturned is going to affect how firearm regulations, I guess, are carried out?
I can't answer. I know what Chevron is, but I can't answer
Well, so Chevron. So what Chevron is? Chevron is basically it was a court opinion that said that when you have to so our Congress, well, it doesn't. It's kind of dysfunctional these days. But even if it was, it's a mess. It's a mess. Even Congress doesn't have enough time in the day to write laws that are specific enough to address the problems and things that we need to resolve as a society. So one of the things that Congress does is it writes laws that grants authority to agencies. And agencies do a lot of rulemaking. It punts out of necessity. And a lot of things require subject matter expertise that Congress might not have. So the Chevron doctrine said that when agencies are interpreting federal law that granted them authority, they got deference in court. That got overturned this past term. So now, what it means in essence is that Congress has to speak more clearly to specific issues, and 10 times more often. It was the attack on Chevron deference was also attack on big government. How does that affect? I think it does affect ATF authority, just like it affects every agency's authority. And we saw there was a bump stock case that got decided this past year. Chevron wasn't specifically at issue in that case, but there's another ATF interpretation case that's up right now, the definition of firearm, ghost guns. It's a ghost gun case. And so, Zen. And, that's good. That's good. Yes. Yeah. No, it's going to be, I think it's going to be important, but it's not just for it's agency action across the board.
Thank you.